Good morning. I'm Al Pfeiffer, and I'm here today with Joe Alioto to talk about antitrust law from the perspective of the plaintiff's bar. Joe is truly one of the lions of the antitrust bar from the plaintiff's side, involved in too many groundbreaking cases to mention over the years. And as part of the Oral History Project, Joe, I wanted to talk to you in some length about your perspective on some of the issues.
Well, I'm delighted to be here, Al, and I appreciate it and honored that you asked me.
Okay. Let me start out with a little bit of history and just talk about how you got started in antitrust law. Obviously, your father was also a giant of the plaintiff's bar, and at the time you started, though, he was mayor of San Francisco, wasn't he?
Yes, he was. But I was brought up, I think that I knew about Sherman and Clayton before I knew about Washington and Lincoln. And I used to have the opportunity to go to trial, see my father in trial when I was a kid. And some of the really great trials, the Goldwyn trial, trials like that. I think I can remember being on the benches, you know, and actually see my feet. So I was pretty young at the time. And I was brought up with the attitude that competition is probably one of the most important aspects of the United States. It's not shared by really any other country in the world. And competition, not only, you know, in the ideas, but also in business. It's very important.
So at the time you were a young lawyer, really just had your license and were starting to practice, you were doing a lot of that on your own because of your father's situation.
I was, and I think that perhaps in some ironic way, it was good that my father was the mayor, because then that meant that I would be able to try cases. Mm-hmm. And because he was in the mayor's office, at the first I began with Max Bleacher, who was in our office, and he was my mentor and hero, and he brought me around to some or many of the trials in the beginning before I became a lawyer. After I took the bar, but before you become a lawyer, I went to a number of trials with him, 2 or 3. And then I began to try cases myself. And because my father was in the mayor's office, there were a lot of people who wanted to try cases. So I must have been averaging anywhere from 3 to 5 trials a year.
How was that, taking on the responsibility of being a first-chair trial lawyer as basically a brand new lawyer? How did you handle that?
Well, I didn't have much choice. And it was kind of throw you in the swimming pool and start swimming. I remember one of my first trials was with, you remember Bill Simon from Howery Simon?
Sure.
And it was one of his first trials, although he had tried many cases at the FTC and other trials, but not an antitrust trial. And I remember that in the very beginning, I had one of the vice presidents of an oil company on the stand. And I remember that Bill objected because there was no foundation for a document that he had given me probably a day before. In those days, you know, they'd give the discovery the day before you started. And so he said there was no foundation. The judge said there was no foundation. I had no idea what they were talking about. I had to get, at the recess, I had to call my old man and say, what the hell is the foundation and what do I do about it? And so it was all a learning process, and I had really no choice or being able to evaluate or be frightened, let's say be frightened, because I had to go from one to another. And I must have had, in those days, 3 or 4 instances in which I left a jury who was out and picked a jury in another part of the country.
Wow. Have you seen the pace of that go down over time?
A lot. And I think that the young lawyers are being deprived of trials and the drama of trials. So the trials are so different because, first of all, you have a situation where you think something is very important in the trial. It probably doesn't mean anything. And something that you never considered does mean something. But because of Rule 12, and Rule 56, the way they're interpreted today, very, very few of the lawyers, young lawyers, get an opportunity to have the experience of a trial. And I think most of them are taking it out on things like depositions, which used to be really discovery-type situations. But now they're turning into the young lawyers only have a chance. This is their only opportunity for cross-examination, and so they're really losing the difference between deposition and trial. I have a very simple statement that I try to tell the young lawyers, and I have to say one thing or two about that, is that the deposition is where you ask questions and you try to get answers. Trial is where you tell the witness what the answer is, and if he doesn't like it, you try to put it down his throat. But when I was practicing trials in the early days, I had the opportunity to go up against a number of the truly great lawyers in the country. They were always older than I was. But what they would do afterwards is they would teach me. So they would tell me, they beat the hell out of me during the trial. I'd be like liquid. The guys would turn me to liquid. I didn't have to push the doors open, for the bar. I just floated underneath. But they would say, Joe, you're not doing this right, and you're not doing that right. You're not introducing the document. They wouldn't give me any of the merits, of course, but they would tell me procedure, And today, instead of that, different lawyers, there's none of that collegiality. There's none of that camaraderie. I feel there's this anxiety to file sanctions against other lawyers. I have a standing instruction with all the people that deal with me that they are not to file any sanction motions against any lawyers. If you don't like what the lawyer's doing, tell him, give him an opportunity to do it. If you're going to file a sanction, it would only be for evidence. So evidentiary sanctions.
Right.
But I don't like the idea
of just
of
going after
the lawyer.
fees.
Right.
Yeah.
Right.
Well, let's talk about that collegiality, because I agree with you that it seems like there's less of it in the practice than there used to be. Let me again take you back a little historical perspective, because you've been practicing based in San Francisco, obviously a national practice, but based in San Francisco, and San Francisco has had I think a certain type of collegial legal community, particularly within the antitrust bar, for a long time. I think it has dissipated some, but maybe give a little perspective on what it was like back in the late 60s, 70s, and how it's changed and maybe why it's changed.
Well, I started practicing in '69, so that was my first year of practice. And at that time, we were at 111 Sutter Street. And many of the plaintiffs' lawyers worked for my father, so Max Bleacher and Fred Firth and all of the Matt Mitchell and all of these really great old-time lawyers.
Did the Severis work?
Yes,
with them
and the
too?
Severis, Guido and Rick, and my cousin Fran Scarpula, and all of these folks are in like class actions and things like that these days. But we were all at 111 Sutter, so we had Thielen, Marin, and Johnson there. McCutcheon was over at the International Building. Yep. We had Brobeck there. Maury Doyle, of course, from McCutcheon, he was fabulous. These great lawyers had respect, in my opinion, for courts and trial process. In those days, it was trial. There were not nearly the emotions and the paper that you have today. As a result of that, you were around people a lot. And there was a real camaraderie among all of the different lawyers. They wouldn't think about filing motions against each other, for sanctions or anything like that. But I think that there's such anxiety among the young lawyers today and the pressure on them. I think a lot of the law firms have turned, in all due respect, to corporate situations. And as a result, they are, effect-oriented. And because of that, these young lawyers think that they have to be tough and hard and like that. And I don't think that there's anything like the kind of camaraderie that used to exist. And that's a shame. When I have trials with young lawyers, I try, on the other side, I try to give them my views about things. And I try to encourage them. As long as it's after, you get in the ring and you fight, right?
Yeah.
But afterwards, I try to bring them to dinner. I certainly have drinks with them afterwards or encourage it. And because I think we're in a great profession and we share that when we get out of the ring. But they're losing it, and so I try to encourage the young lawyers to try to move away from some of this modern view that you have to be really tough. You can be tough in the ring, but not outside.
You've touched on a problem. I see it as a problem. I guess maybe that betrays my
Yes.
bias in this, that there isn't nearly as much trial opportunity as there used to be in antitrust.
No question.
You face that with the people that come up through your firm as well. How do you address that problem of there just not being as many opportunities?
I see a lot of lawyers. I try to tell them, we used to have a lot of trials. Maybe it's a good idea to go to the government and do criminal cases. At least you'll get a trial. Many lawyers do not get the opportunity to see juries, to understand that they're just folks. They think that the jury box, is something either for the excess lawyers when they pack the courtroom, or for the press or something.
Yeah.
And that's a real shame. And I would wish that there would be more antitrust trials. But the judges, the courts are making it extremely difficult. We never used to fool around with Rule 12 and Rule 56. I had a judge in the South. I forget where it was, but he had in his chambers. He had a little sign, and it's something to the effect that in this court there's no spitting and no summary judgment. And so it kind of said it. And so it means that you file the case, you file an answer, you're in trial. But that's not present today. So I try to encourage people, even those against me, to go to trial. I don't try to use it as a threat. It's not. It's a real part of our history, and an important part. And whether you win or you lose, you go in there and you do your best, but you're presenting your case to the jury. Now, it used to be, this is interesting, the Supreme Court, the older Supreme Court, the guys who went through the Depression and World War II, those guys, and they said that the jury was an essential part of the congressional plan to make competition rather than monopoly the rule of trade in the United States. Essential. In other words, you couldn't go without it. Well, now, it's very, very rare that you even get a trial. And that is a real, in my opinion, a real shame. Also, it would unclog the courts because they wouldn't pay attention. They get like a summary judgment, it's 10 feet tall, right? They can't find a material fact anywhere there, right? They should throw it out. The old judges would never pay attention to that.
So, in terms of the change that you're talking about, what other sort of policy changes have you seen that you think have really changed the practice of antitrust law?
It used to be very clear. Per se rules were very, very clear. Price fixing, out. Tying, out. Group boycott, out. Retail price maintenance, out. You couldn't do it. Territorial division, customer division. Per se rules were easy to understand. Now they have fogged them up so much. I don't know what happened to attempt to monopolize. I think it kind of went into its own cloud, right? And of course, nobody, you can't bring a monopoly case. Very rarely can you bring one of those. But those rules have changed so much that it's very difficult to understand actually what's going on. And the courts are struggling with it because they changed the rules. And they want to make it like what they call rule of reason. Rule of reason originally was really rule of reason. It was the old Chicago Board case. And it was easy to argue that with a jury, and it was easy, I think, to prove it. Now, the requirement goes into the relevant market in such a way under rule of reason. You have to show the impact, on the market of the restraint. That they have these experts, millions of dollars, and nobody knows what is going on actually. So they make they make the cases almost impossible, whereas before they're very clear. I'll give you another example because I've had these with your firm. The mergers. The mergers are out of control, and they result in a very bad impact, in my opinion, on our country. They always result in 10, 20,000 jobs that are thrown out the window. There's you lose a rival. There's no real price competition when you buy a significant rival. There's no innovation. This hurts our country. Well, it used to be before, if you even thought about it, you'd be out the window. But look what has happened, Exxon and Mobil, give me a break. Or even 2 weeks ago, AT&T and Mobil. Could you believe that?
Well,
I'm gonna do something about that one.
I would say I think that one has some miles to travel before we know whether it's going to get through or not.
But the government has not been good.
Well, that's what I was going to. What do you think? Let's get to mergers first, and then we'll come back to the broader issue of just antitrust policy.
Yes.
But in mergers, that one obviously the government drives that policy change.
I have told the government, in all due respect to them, that my belief is that they are acting as the handmaidens of the monopolists, and they help the monopolies instead of protecting the people and competition. These mergers are very harmful, in my view, to our country. The greatest social program of all is a job. No question about it. Okay, that is the first thing that is sacrificed in a merger among rivals.
Well, one of the challenges, you have to show efficiencies. And,
efficiency is a new word, and it's not really in the lexicon of the original cases of the 1960s and early 70s, which have never been reversed. Mm-hmm. Efficiency is the new thing out of, or was the new thing and is the new thing out of Chicago. But here's the point. What efficiency does is it takes away from the antitrust laws the very strong purpose behind the social importance and the political importance of enforcement of the antitrust laws. It makes it solely an economic view. Now, you want efficiency? That's totalitarian. That is not our government. Our government is, if you want to say inefficient and messy, that's the way we operate. We have freedom of speech. That's not efficient. We have a government that is always in debate. If you want real efficiency, fine. Go to World War II. You got plenty of those characters who were very, very efficient. They made the trains run on time, and every soldier obeyed everything.
Now, to be fair, some would disagree that that's efficiency. In fact, one of the prime criticisms of monopolies is that they're not efficient. So,
of course they're not, because there's no competition. Every night, if there's competition, these executives would have to think every night, what is that other guy going to do? What is he going to do? And in order to meet that test, they have to think about what they're going to do. Mm-hmm. And they have to come up with something new. They have to come up with a better price. They have to come up with a better distribution. They have to come up with better efficiencies in their costs and their structures.
Sure.
They have to do that. Okay, when you eliminate that, you eliminate all of it. So they don't have to do anything. So they sleep well at night. No CEO should be allowed to sleep well at night.
I'm not sure how many do, but we may be getting a little off our topic here.
Okay.
But let me bring it just in terms of the on the non-merger side, on the
yes.
Just antitrust enforcement non-merger side. You've also seen changes in sort of the policy. You mentioned Chicago, for example. Have you seen more emphasis just on economics? Let's leave the Chicago side of it. Have you seen more emphasis on economics in the time that you've been practicing?
Yes, but in a substantially different way.
Okay.
And I've also seen the government be on the side of the defendants. And when I argue a case before the Supreme Court, it's very difficult to see the United States government on the other side in the morning suit. I said, why don't you just sign up with the defendants, right? What are they doing? What are they doing over there? I don't know how many different cases in which the department is taking the position of the defendants in almost all of the different cases that went in front of the Supreme Court, and taking their position and asking the Supreme Court to take those different cases in order to dump some kind of rule under the antitrust laws. So the government policy has changed, in my opinion, dramatically, and it is against the effective enforcement of the antitrust laws, and it goes on the other side. Economics comes into it, but in a different way, mm-hmm. and sometimes very unrealistic. For instance, the court in Zenith, and I think, and then the tobacco case, they would require an economic view that is not realistic. For example, in an attempt to monopolize case, if somebody is cutting the price at predatory prices, you have to prove that they intend to get it back later. Well, of course they do. But how are you going to prove that? Rockefeller used to call it a sweating. Oh, we'll give this guy a sweating. So he sweats them underneath, right? But do you see when they intend to get it back? We have a lot of problems with, for instance, our friends in Asia. And the Japanese had a view, a long-term view, one that we would think absolutely ridiculous, 150 years. Mm-hmm. Can you imagine that? It was more important to get market share and control than the prices and the profits at the time. So,
but not a very practical thing today. In the American publicly traded company environment, where the next quarter is your vital report to the investment community, it doesn't seem like a 150-year timeline is probably realistic for recoupment of.
They don't have to do it anymore. They just buy their rival. And and by buying their rival, that helps them on their quarterly report. You have a good example, for instance, Pfizer. Pfizer was in deep trouble. Pfizer had just a few drugs that were major drugs. Okay, it has 6 or 7 research and development plants. Instead, it buys Wyeth, shuts down those 6 or 7 plants, mm-hmm. and Wyeth gives them what they need. You see that every single day. So no one is going out into the market to compete. They're doing the quarterly deal, as you're talking about, and the way they do it is real simple. They just buy their rival, and then that's part of their sheet.
And the change in the government approach to who can buy whom, it doesn't seem to be political party bound. I don't think you've seen massive shifts in merger enforcement from the Democratic administration to the next Republican administration to the next Democratic, have you?
You're absolutely correct.
So what's driving that?
Well, I've complained about it, and I've complained to the Attorney General about it, and I've complained to the Chief of the Antitrust Division about it. I mean, it's really interesting because there hasn't been that kind of shift. As a matter of fact, I think that the last time we had really effective enforcement was probably with President Ford, of all people, because the statute was changed. But certainly since President Nixon, and really since 1980, President Reagan, mm-hmm. the attitude toward antitrust has gone straight downhill. And I think that there was this feeling that if you did not agree with Bork, for instance, Judge Bork, on his book, if you didn't agree with that kind of economic analysis, you were stupid. And I think that, and then they actually had schools for the federal judges, if you can believe it, where it was kind of an indoctrination. Most judges don't know beans about economics, right? Mm-hmm. We're lawyers, that was one of the things that we really weren't heavy in, perhaps. But you get this education saying, basically, well, if you don't agree with these economic theories, then you really don't understand economics. But prior to that, and this was a real indoctrination, started in the 80s. Mm-hmm. Judge Bork, in his book, actually told us what he was going to do. He felt he was going to attack 2 things. First, the judiciary, to convince them to come on his view, and then to get rid of the social and political aspects of antitrust enforcement. And those aspects are extraordinarily important. I mean, you go back to the Republican, Theodore Roosevelt. Mm-hmm. And the reason that he enforced the laws because he thought Morgan figured that he was more powerful than the president was. And so President Roosevelt had to show him, well, that wasn't so. I have to add that, of course, he put on Oliver Wendell Holmes on the court. Mm-hmm. And then later Holmes went the other way. And so President Roosevelt said, well, there's more backbone in a ripe banana than there is in Oliver Wendell Holmes. See, so he saw that economic power, when it's unleashed and without not regulation, without real competition, is a political threat. And of course, it's a social threat as well. I want to say one thing that is extraordinarily important, I think.
Yeah.
If the government regulates any kind of enterprise, people don't like regulation, they like freedom. in the United States. And if there's any regulation, you don't like it, you vote the bum out, right? Get rid of them, and then put somebody in who's going to do that. The antitrust laws are referred to as being a law of regulation. They're not. What they are is exactly the opposite. What they do is they tell private people, look, we can't vote you out, but we're going to make sure that you compete. We don't want to regulate your trade. We want to make sure you don't regulate trade. You don't fix the price. You don't divide the market or the customer. You don't tie a product, or you don't monopolize or try to monopolize so that you could have the power to eliminate a competitor unlawfully or fix the price unlawfully. It's very important to know that the antitrust laws are a law of deregulation, not regulation.
Yeah, I think actually a lot of folks would agree with you about that.
Well, that's good. That's the first I heard that. I've had plenty of judges tell me the opposite and arguing in the Court of Appeals. They would say, hey, what are you talking about?
The judges, though, that one thing that you see over and over again, I'm sure you've seen whenever you get to a remedial stage, is the judges don't want to be left regulating. I think Judge Green with AT&T was one of the rare examples where he was really regulating that side of the industry for a long time. Most judges really don't want to be involved.
I agree, and I think before it was very easy. I mean, if you had a merger, they said, okay, you can't do it, period, that's it. See you later. They didn't try to run businesses. I think that any time the government tries to run businesses is not good. I think that if somebody achieves a position in an industry lawfully, I think that they should be rewarded. I don't think that bigness alone is a reason to knock out a company. On the other hand, the problem with size is that it carries with it, as the Supreme Court has said many times, the opportunity for abuse, which is practically always utilized, and that's the problem about it. So, and then, you know, any of this stuff looking at the competitors. I have to say one thing about the government. I'm involved in this case on the West Coast called the LCD case, which are the flat panels. And I think that the government, those young people out there, did a great job. I think that they were able to secure fines of almost $1 billion. They sent a lot of guys to jail. Unfortunately, when we were taking the deposition of one of the fellows, you know, and who went to jail, you know, I said, well, you know, you went to prison, right? He says, no, I was in camp. So they sent him someplace, and then they rewarded him afterwards, and they keep their job and everything. It's like the mob. And so it's amazing. But I think, for instance, I think that was a good shot by the government and by the young folks that were out there on the West Coast. And I think that they did a real good job there. I think that people, businesses should understand that it's very important, the antitrust laws, and if you violate them, I think that these guys should go to jail, in my opinion.
Well, it's funny you bring that up. I was gonna talk to you about that. The San Francisco DOJ has actually been very active over the last several years with a number of cartel investigations, and have the fines have well exceeded $1 billion, and people have gone to jail.
Right. Gary Spratling, remember, he did he's out of the West Coast, and he did the vitamin case. Joel Sanders, I had a trial with Joel. We had in Sacramento. He beat my brains out. He was with the government. He was with the government then. I don't know what I was doing. I was trying to do a plaintiff case, you know, for a defendant. But they're very excellent lawyers. Niall Lynch and his group are terrific, I think. I think they've done a great job. I know that a lot of these lawyers, they've all gone to defense firms, and all due respect, Al, but they've all gone to defense firms, and I wish they would do, think about going to plaintiffs or bringing plaintiff cases. I'd love to see more plaintiff cases. I think that if the big firms started taking on plaintiff cases, and I saw in the newspaper that they're putting a lot of the defense firms on contingencies now to win. I saw that in the newspaper about Howry, and I couldn't believe that. But I think that would be great. These guys are very, very talented lawyers. They tried a couple of cases, won some, lost some. So what? At least they did it.
Yeah, I don't think you were or Max Bleacher were ever afraid to try a case on the theory you might lose it.
I have to tell you that for me, a trial is invigorating. Being out of trial is where, you know, it's you feel like you're not actually doing anything. A trial is exciting, and you can't change the facts. You try to develop the facts. The facts are what they are, or what you get in discovery. Sometimes they don't tell you everything. But you do the best that you can. And if you win, great. And if you lose, you lose. One
of the challenges that we face, I guess I have been fortunate enough to actually try antitrust cases as well.
I know.
One of the challenges I think we face is that, particularly as the economics has become more and more a part of an antitrust case, we're still dealing with people as the ultimate triers of fact, especially when they're in the jury box. How do you deal in this increasingly economics-focused antitrust environment? How do you deal with getting the message across in terms that people can understand?
I have to tell you that I'm giving you a trade secret.
Okay. Thank you.
Okay. The trade secret is that by far, in my opinion, or used to be at least, the best jurors were the housewives. And I don't want to sound sexist, but they were very important because they were in charge of the budget of their house. They would go to the market. I would spend a lot of time going through a grocery store just to watch. They will make a difference between $1 here and $1 there. They'll do the coupons. They know how important it is, prices, how important prices are, how important the products are. And they understand that immediately. I've told juries plenty of times, if you think you don't understand something, it's because the lawyers just plain didn't tell you or didn't want you to know. Economics is easy to understand in my opinion, and easy to convey to a jury. You're not throwing the wool over their eyes. I've heard judges who've criticized juries and think that they're too stupid or not smart enough to be able to handle difficult issues like economics and antitrust, and that's a fraud on our government. Because these are the people that put these people, in office. We operate by the consent of the people. That's who they are. And how difficult is it to get a unanimous verdict? I mean, in the federal court, it's unanimous,
Right.
And how difficult is that? There's nothing that we do that is unanimous. And if a jury feels unanimously one way or another, they definitely have the idea as to what it's about. So I don't think that's proving. I don't think economics is an issue really at all to jurors. Now I have to say something else too.
Yeah.
I don't know one case that was either won or lost because of an expert economist. I don't know one. And I don't think, and I never used to use an expert.
I was going to ask you, that's changed over time.
Yeah,
right?
We had accountants maybe, to add things up. Or we used to add it up on the board, right? Sometimes before the defendants knew that we were actually adding up the damages, right? But we had to come up with experts because the defendants had them. It was an erasure. You got a guy, okay, they're out. It's a neutralizing thing. Who wanted experts? The judges did. Jurors couldn't care less, in my opinion. And every time, I don't know how many trials in which, generally, I don't talk to jurors after trials. I might bring them for a drink or something, but generally no. But the point is that they are not impressed at all with the economists. They want to know what the conduct is. They want to know what the impact is, and they can figure out the impact. The economists will come in, they'll have a book like this, and then they'll have one page that everyone's supposed to, that's supposed to be the end all of everything. But it's not. They can understand supply and demand. Adam Smith is not a difficult guy to understand. I'll tell you this, most of the economists on the stand, they don't read Adam Smith. The greatest cross-examination piece of material that you could have to knock the hell out of an economist, whether he's a Nobel guy or not, and they usually are, on the other side, is Adam Smith. They all know who he is, but none of them ever read him. He's great. He was against the monopolies. He was against the combines. The whole point of his view was the free enterprise system, the real free enterprise system. The Secretary of Labor, I forgot, he was with President Clinton, nice guy.
Robert Reich?
Yes.
Yes.
Yeah. Okay. He thinks that Adam Smith was greedy, that he was promoting greed. He wasn't. It was exactly the opposite. Adam Smith was talking about, yeah, you have your self-interest in the invisible hand and all of that. You do have your self-interest. However, it is to promote, it by its nature promotes competition, promotes social welfare and political independence. And he had a whole book against what he called the mercantilists, which were the monopolists of those days, who would cut off trade. And you know, the greatest example that he used was the United States against England. And he thought that what should happen is that the capital of the English Empire should be changed to Washington. How do you like that? Nobody knows that. And that was because the Americans were industrious, the Americans were providing more jobs, the Americans were providing more trade, and the British were trying to stop them from doing it. They didn't want them to add value to anything, just raw products. And that's why it's in the Declaration, you know, that one of the causes of the indictment against George III was that he was cutting off trade of the United States, of the colonies, with other countries as well as with England itself.
Well, you know, but at its core, I think the economics of antitrust does assume that sort of Smithian self-interest, and assumes that people are going to act in that way.
No, they don't. The economists that come into trial present phony relevant markets. They present phony analyses with regard to impact. The people are not fooled by that. Judges are, I have to say, some of them, not all of them, of course, but some of them are. Like, for instance, some judges are saying there's no such thing as national markets anymore. There's no such thing as a national market of airlines. Two airlines can combine because New York to Washington does not compete with San Francisco, L.A. Give me a break. It's all, you know, it's all transportation of people throughout the United States. So they do these little analyses, economic analyses, that a jury would never do.
Well, but does part of that lay at the feet of the government? Oh, of course.
Yeah, thanks.
You know, because I think you've seen the DOJ and the FTC, depending on the context of what they're doing, sometimes they're arguing for really broad markets, and sometimes they're arguing for really narrow markets. And
that's okay. That's okay too. There's nothing wrong with analysis of sub-markets, because that's out of Brown Shoe.
Yeah, but however,
but you can't be unrealistic.
Right.
I mean, like, for instance, the largest brewing company in the world comes into the United States and buys Anheuser-Busch, and they're circled all around the United States, and they're ready to come in. And the government says that's okay? Where does that come from? What would have happened if they came in? We know what would have happened, because they had one part of New York in which they did compete. And in that part, there were like 4 or 5 competitors, and they all had the equal number of shares, 20% or whatever it was. In the rest of the market, they had 50% Anheuser-Busch. Miller in that group, that combined too, that was 35%. There were practically nobody who was competing. So in comes the largest brewer in the world. And instead of requiring them to compete, which would have lowered the prices, which would have created jobs, instead they allow them to buy Anheuser-Busch, and the first thing they do is they fire guys right away, and then the price increases. And remember, 6 months later, the guy from Anheuser-Busch tries to pretend when he had an agreement on prices with Coors, he goes, oh, yeah, no, I really didn't do that. In the paper, it was so bad. It was so bad. And what does the government do? These guys are on no dose. I mean, that's what they need. It seems to me they're sleeping through this. Isn't it a matter of common sense that has to be something that hurts our government and our people? I have to give you one statement that I think is important.
Sure.
Karl Marx, when he wrote Das Kapital in the London Library, one of the things he said to his mother, I just wrote a book, Das Kapital. She says, that's great, why don't you go out and make some? But when he wrote it, he knew that monopoly was the key, because if monopoly was allowed, then the people would ultimately overthrow it. So when he makes his favorite or very famous statement about the expropriators will be expropriated, that is in the same paragraph where he talks about monopoly and how that, okay, what didn't he figure out about the United States? Two things. One were unions, and the other was the antitrust laws. And the antitrust laws, when we had deregulation in 1978, do you have any idea how great it would have been if at the same time they enforced the antitrust laws? But they didn't. As soon as they were deregulated, they allowed merger after merger after merger in all of these different industries.
But again, that's continued for, I mean, with some tweaks perhaps from administration to administration, but basically that, I think people would agree there's been less stringent merger enforcement, and there is no sort of clamoring in the street. I mean, this is not a situation where the people are saying this is wrong, we think this is bad for the economy, and saying throw the rascals out.
This is how wily Judge Bork was. He sensed that the group that would ordinarily be very much opposed to this anti-competitive activity was concentrating more on the ecological issues and the environment. And he said, in his book, this guy was great. I'd love to cross-examine him because he put out the master plan. He says that this group, that nobody's paying attention to the antitrust laws. They're all going toward the environment. So this is definitely the right time to start attacking the antitrust laws. It would never have worked after the war, after World War II or something like that. None of this would have been allowed to happen. By the way, the merger law is interesting because all of those cases in the 60s, they've never been overruled. And Judge Posner, it was great. I mean, I'm not a big fan of Judge Posner.
He's a brilliant man.
He's not brilliant. He is extra brilliant. That's the problem. He is very, very smart person. And I believe in one case, the FTC case against HCA, where they took a merger where the government won in Chattanooga, and they brought it up to Illinois, and they somehow got in front of him. And I think he was disturbed by that because he actually talks about it in the decision. But he says in the decision, he also, by the way, had a great antitrust decision, in my opinion, in the fructose case on conspiracy. He really understood what I'm just talking about in the old days where, he wanted to get rid of monopoly and all that. When I was reading his book, I was going crazy. But in the HCA case, he said, the merger laws have not changed. I mean, these cases in 1960 have not been overruled. So they're the governing, now, he says, I don't necessarily agree with it, but that's where it is. And that is a real important distinction. And you know what else he said in that case? He said that, he encapsulated all of those cases. And he said if a non-trivial merger of an acquisition of a significant rival, that was bad, according to his interpretation of the old cases, because the old cases felt, and he uses it, the social and political aspects of the anti-merger laws, not the economic ones. And so he saw
hard to quantify the social impacts, though,
no, it's not. No, it's not. In Brown Shoe, they even said it. What creates jobs? Internal expansion. What eliminates jobs? Mergers. First thing. Because you have a salesman and a salesman, you don't need the two anymore. They're not competing. They either get rid of one or they get rid of both. I mean, look at the last mergers. Look at the last few mergers. You're not talking insignificant numbers. You're talking 10 to 20,000 people, families eliminated by an anti-competitive merger. On the other hand, if these companies, just like Pfizer, right? 7 research and development plants, down the tubes.
Oh, but the question is, I'm not involved in any of these cases that we're discussing.
It's okay if you're involved in it.
I'm not. None of these are my clients. No offense to anybody. But
they are your clients. That's right. I forgot.
I didn't even know they are. But they're not my client, I can tell you that. But in those situations, I think there's a legitimate concern on behalf of the people who are merging that they need these efficiencies, that they're not going to be able to compete. I mean, it is, I think when you talk about markets, the markets are often international.
What are the
always.
efficiencies? Look at this. There's two companies, and they both have factories. And they're operating, let's say they're operating at 50% capacity. Mm-hmm. Okay. If they say, well, I want to buy this other guy, because then my factory will operate at 100%. Mm-hmm. And I will be more efficient, they say. Wrong. That is not the efficiency of competition. That is not Adam Smith. He says they're both going at 50%. This guy has to figure, cut the cost, get more efficient plants, modernize. Then this guy modernizes, and then you have that kind of competition. So what?
But even in the non-merger context, I think when you look at certainly even American companies that have really thrived by cutting costs, what you've got are some giant outfits that I won't name that end up just cutting the salaries.
I'll tell you something. I have to tell you something right off the bat. Every one of these are justified theoretically, mm-hmm. By the government and by the defense counsel, and all due respect to all those very, very, very bright defense lawyers who have a lot of fun beating me up. When they talk about efficiency, that's what they use as an excuse. Nobody questions the CEO. They all say, we have these efficiencies, we've cut the cost, we're going to pass it on to the consumer. Lie. Every time I've got a CEO who used that, I said, now, did you pass, how much cost did you save? $1 billion a year. That's great. Did you pass anything on? I mean, did you lower your prices? No. Well, why not? You cut your costs. Why didn't you lower your price? Hey, I'm making more profit. None of them. They use the excuse that they're passing it on to the consumers, and that is just an absolute fraud. And all you have to do is take the deposition of the CEO, which nobody takes. So there's none of them. I don't think you could come up with one case. I had the two guys in the oil industry. I mean, flat out. You don't say, did you pass it on? You say, did you lower your price after you saved all this money? No. Mm-hmm. Did you increase your production? Yeah. Well, did you increase your prices? Oh, yeah. So you made more, and you increased more, and you eliminated a competitor, and then you didn't pass anything on. So every time you hear somebody say, this is good because it's more efficient, it will cut our costs, and that's good for the consumers, it's the last part that is never proven. And if they went to the proof, they would find the opposite. What do you think about that?
Joe, I think it's been a pleasure talking to you. I really do appreciate your giving the plaintiff's perspective on all this. Thanks very much.
Thank you, Al. It was my pleasure.